And finally, in closing, we will have some comments from Intellectual Property High Court Chief Judge Otaka Ichiro. Chief Judge Otaka, please.
First of all, I would like to express my deepest appreciation for the participation of IP judges online from China, Korea, and India. As IP disputes have become internationalization with growing globalization of business activities, the importance of mutual understanding of our respective IP dispute resolution systems cannot be exaggerated. At the same time, rapid progress of technologies has been elevating the significance of methods for proper utilization of expert knowledge in litigations. I am convinced that through the program, we have deepened such mutual understanding and provided beneficial information for not only the IP practitioners, but also the practitioners in other fields.
And from here, I'd like to switch to Japanese. So thank you very much for watching this program organized by the IP High Court. Thank you for staying with us over this longer session. And we invited practitioners. The tradition has been to invite practitioners from various countries, and we do mock trials and panel discussions face-to-face, and we have you watch in the hall. But because of COVID, following on from last year, we delivered through web streaming. And thank you to all the participants for your cooperation in setting up the web environment and downloading the materials. With your help, we were able to conclude this program without major issues. This year, we were able to do the mock trial live. Last year, it was pre-recorded, and I think, therefore, it was more convincing. And we like to make more creative improvements in the future. So indirect infringement was one topic. For the mock case, we saw that in those countries where indirect infringement is allowed for, although the logic was different, the conclusion was same, and also in those countries where it does not exist, it was concluded that direct infringement was established under certain conditions. I thought this was rooted in the common sense of value that if the manufacturer and sale of the subject product creates the same profit situation as direct infringement, then the patent right should be effective. In addition, from the viewpoint of harmonizing the protection of inventions with the protection of predictability and profits of third parties, I felt that there's a common awareness of the need to formulate business rules for similar cases, as well as to resolve individual disputes through legal interpretation. With the globalization of the economy, it's a characteristic of IP disputes that countries all over the world face common legal problems, such as this mock case, and I was reminded of the need to continue to closely exchange information and opinions with other countries. The other theme of this year's conference was use of expert knowledge. Each country has a common understanding that it's necessary to properly involve experts and utilize their expertise in order to conduct proper and speedy trials in civil cases that require expertise. It was meaningful that each participant shared their systems and practice. I'd like to thank every one of you who participated in this court-sponsored program, and I'd like to conclude the court segment of this symposium. Thank you very much.
Thank you very much, Judge Otaka.